Welcome back to the Texas Appellate Law Podcast. I'm Todd Smith.
And I'm Jody Sanders.
We have as our guest Dylan Russell from Houston. Dylan, welcome to the podcast.
Thanks for having me. I'm a longtime fan and I run every day. So every morning I'm listening to whatever the next podcast is. And this is one I always listen to, no doubt.
Well, we're happy to be in your rotation. Thank you.
I think that's three episodes in a row. We've had a little expression of fandom from our guests. So thanks for saying that, Dylan.
I know. Let's keep the streak alive. I kind of like this.
Yeah. You guys are definitely, keeping my ego inflated. Well, no, seriously, we're happy to have you. And I think, you bring some unique perspective to the practice of law and appellate law specifically. Before we get into that, though, tell our listeners a little bit about yourself, how you came to the law, and let's just get the conversation started that way.
Yeah, well, so I'm Austin born, Texas raised, born at Breckenridge Hospital, 100 yards or so from five. I'm sure we've all spent some time stopped in traffic somewhere on there over 50 years ago. Had family in Houston, family kind of near the Dallas area, but, until I started law school in 2000, stayed in Austin, went to school there, went to the LBJ Science Academy in part to avoid going to the school where my mom and stepdad taught, which is the school I would have been zoned to, Reagan High School. So, and then went to UT Austin. And as you'll be able to tell from my undergraduate degree, law school was not remotely something on my mind because I graduated with a degree in saxophone performance with jazz concentration, which was one of two choices that I was making in my senior year of high school between being a psychiatrist or being a jazz musician. So I went with the jazz musician.
Well, there's a lot of overlap between those two, right? I mean,
well, you laugh, and understandably so. But I have an uncle who has a music degree and is a board certified commercial real estate attorney. And I won't give him too much identifying information, but he's a extremely talented attorney in the Austin area. And I definitely asked him for some tips and thoughts when I ultimately did start thinking about law school. So
I really wasn't being too facetious. I mean, I just had the thought of, do you think about laid back jazz and sort of the mentality of jazz? It kind of fits with the psychology.
Yeah. Well, I think I've been in the practice of law now. What I'm doing now is, as you guys well know, probably a little bit closer to psychiatry than jazz. Definitely, there's two brain types who become great jazz musicians. A few of them have sort of both. I was definitely a little bit of natural talent, but mostly the hard work and the focus and the study and the really analyzing, how the best saxophone players or whatever did it. So the long hours and the study and the serious practice translated pretty well to law school, I think, once I got there, not having a clue exactly what I was up against when I started by any means.
Well, so then you found your way to law school. What kinds of things were you involved in law school that shaped where you are today?
Yeah. So I'll tell you that before I get to that, there was one seed planted in my mind. He was probably the top trumpet player in the entire state, in the state competitions, made first chair state pretty much every year, a few years ahead of me. And I remember, I think it was his senior year, and I was probably a sophomore freshman at UT, and I overheard that he was studying for the LSAT, and I had no clue what that was. And it was, years later that, some life events happened, and I decided, let's maybe try something different. And so headed to law school. And then once I got there, I did, as South Texas has, one of the top, if not the top moot court programs in the country. I think more nationwide wins than any other law school. And I tried out with the late Dean Treese to be on the moot court team. And he was very, very nice and friendly, but I didn't make the cut, apparently. So I did end up on law review, which I think I have found, at least with people that I know, sort of in my, the time that I ended up graduating, a lot of the folks who were on law review ended up doing appellate law, unlike the guys that were on the moot court team. There's exceptions to that, but I think the skill of research and writing on the law review really helped ultimately when I started to do some initial appellate work when I got into practice.
So I want to make clear, because I'm not sure I heard it, who was the trumpet player that you were referencing?
His name, unfortunately, he passed in a car accident, but his name was Tom Caswell, and he worked at the Dallas office of Thompson Knight, I believe, right out of law school, and very successful, did well, but unfortunately passed in a tragic car accident. But such a great guy, awesome trumpet player. I'm blanking now on the high school. It's the school colors have Crockett. He went to Crockett High School, which was, one of the sort of competitor high schools in the Austin area with having some of the top musicians. LBJ was probably, up there with that school. And then Westlake was getting started. But yeah, he was an inspiration to me, not knowing that I was going to be inspired years later to follow in those kinds of footsteps.
So you're on law review, excuse me. You're on law review at South Texas. And what did things look like for you as you were getting ready to leave? Did you have a path charted from there, or how did that go?
Yeah. I mean, I definitely knew when I started law school that I was going to go the litigation route. And my uncle, who I'd mentioned, I kind of talked to him about that big divide usually that most law school students or lawyers think about. Am I going to go transactional or am I going to go litigation? And of course, the other divide is the criminal civil. If you do litigation, I won't use the exact words he gave to me, but in so many words, he said, I always heard in litigation, you're going to come up against a bunch of blank, fill in the blank. And as it turns out, he found out that there's just as many in the transactional world. But, that didn't bother me. So I was happy to go into litigation, and I definitely had planned on being a trial lawyer and did end up trying a lot of cases, civil commercial litigation for, a number of years. So yeah, that was the plan, and I stuck with the plan. Now I had some good mentors. My first summer, I was lucky to be hired as an intern with the 14th Court of Appeals with then Associate and later Chief Justice Frost. And then the second half of the summer, I didn't have a job, but someone had, I guess, skipped out on working for Justice John Anderson the second half. And so I was happy to fill that spot. So I worked the whole summer, that first summer, at the 14th Court of Appeals. And that was when I first realized that I didn't have a clue how to do legal writing yet. So I'm glad that I learned that then. And then my last year, I had the great opportunity to intern for then magistrate judge Marcia Crone, who's now an Article III district court judge in Beaumont. And for those who were graduating law school and started when I did, it was a great time to be in law school, because for those who will remember 2000 to 2003, we had three pretty major events in the legal world. We had Bush versus Gore, we had Enron, and we had 9/11. So all three of those events in law school made it pretty interesting.
Oh, no doubt about it. You were already in Houston, so Enron was just right there.
Yeah, I got to, when I was interning during the school year for Judge Crone, we got to see some of the big cases that were, I think, in Judge Harmon's court at the time. Some of, I think, CalPERS, brought some litigation, and I remember one of the lawyers, I think his name was Larac, was down there with a big box of documents, and he was kind of putting on a show for the judge. So that was all pretty exciting to watch.
Okay, so you get out and you start doing litigation work. Now, as I recall, and we're going to get into your current practice situation and the details of that, but as I remember, you were with a sort of defense-oriented firm for a number of years. Is that where you went straight out of law school, or did you have?
Yeah, so the second summer, I got a summer clerkship at Hoover Slovacek. It was then Hoover Bax and Slovacek. I never met Mr. Bax. He had retired before I got there. Mr. Hoover had, passed years before, and his family, allowed the firm to keep his name. And then Mr. Slovacek was there. We were about 25 attorneys when I started. They hired me, of course, after I graduated, and stayed there doing all kinds of commercial litigation. In fact, I got my first appeal and oral argument pretty early. I mean, it might have been my first or second year that just happened to be a case out of Brazos County. So that, of course, went to Waco Court of Appeals. And then I had another one maybe a year or so later. It was a Corpus Christi Court of Appeals case that I got to argue. So pretty early on, I was arguing some appeals, mainly because I was the guy that wrote the briefs and thus would have been the best person to handle it. And we definitely had some folks that had handled appeals before, but most of the lawyers there were about 2/3 trial lawyers and a third transactional. And when we had a big case that might have gone to the Texas Supreme Court, then they would often hire outside specialists to help with those kinds of things. But over the years, I started getting more and more appellate work. And so, I ended up being sort of the appellate guy.
Well, it's funny, when I talk to young lawyers, if they're really interested in doing appellate work, I tell them, look, go and, you got to raise your hand and volunteer for this kind of thing. There's different ways of going about it, but that's for somebody who knows that that's what they want to do. And if there's not an established group in the firm, that's typically what I would recommend is just, hey, go and do that kind of work. And kind of sounds like that's more or less what wound up happening, at least, maybe not exactly that same way, but you kind of became the person in the firm that was known for having this skill set and being able to do the work.
Yeah, pretty much. And so I talked to our now district court judge of the 157th, Tanya Garrison, who had the same kind of, role in her firm. And she in a mid-sized litigation firm in the Houston area. And she, kind of intended to become the appellate specialist and did in fact become that. And I had basically taken the same route, not knowing, that was a way to do it. And I didn't necessarily plan on doing it. It was just, I like to do everything. I didn't like to turn down work. And so, I think I definitely had some ideas on how to write, and I definitely looked at the pros, those, repeat practitioners that you see at the Texas Supreme Court, and would steal from them. Kevin Dubose, does some great CLEs that I would read up on. And so trying to learn from the best and slowly got to where I kind of had my own style of writing. And then, at South Texas, I definitely learned some tips and tricks on sort of oral argument preparation that I still use to this day. And every time I think, well, maybe I'll try something different, I realize, if it's worked in the past, why would I change it up?
Yeah.
Don't mess with a good thing.
Yeah, for sure. Were there any, you said you realized during your internship after your 1L year that you didn't know as much as you thought you knew about legal writing, and you've talked about honing your writing skills. Were there any particular sources besides like the DuBose CLEs, or were there outside sources that you referred to? A lot of people talk about Brian Garner, some other resources. Was there anything in particular that helped you to develop your style?
Well, I think, I was so green when working for Justice Frost that I don't know that that was just the moment of awakening, realizing I still had a long way to go. But I do think, what I would tell young lawyers when I was more experienced and we'd have, new associates or summer clerks, the way I kind of approached it was, if you could write like a judge who could write well, the only difference being, of course, you're now advocating as opposed to, acting as the umpire, deciding who wins and who loses. But if you write like a judge, then you would assume be persuasive to a judge. You're just going to do it in a more persuasive way. But as far as, the technical part, the way it looks, the citation to authorities, that was sort of my approach. I use Garner for, more usage issues, but I definitely don't follow Garner's approach to brief writing per se. But I think basically the following judges and Judge Crone, boy, she had a system down that was quite amazing. She had physical binders with, essentially, if it was an area of law that she had written on before, she had a whole binder of case law, and so you could just kind of go pick it apart. And then for something new, you would do the research, and her clerk would make sure it was correct, and then sort of add it to the binder. So she had a real system. So those were the beginning stages. But basically it was, once I got, let's say in my fifth, somewhere between 5 and 10 years, when I started getting much more involved in a consistent appellate practice, it was just looking at the attorneys former justices, top board certified appellate attorneys and just kind of stealing from them. And then, looking at opinions written by, Elena Kagan. Can't go wrong with how she writes. So those are kind of, but I also try to keep it, as far as my writing goes, I definitely try to keep it mine so that it looks like mine. In those few occasions where I've had to collaborate with other brief writers on one brief, it's never the same. It's not the same. I know y'all have had Rafi on, and I think he called it Frankenbrief, when you have multiple brief writers.
Yep.
And so I try to avoid that so that at least it's clear it's coming from one voice. At least that's basically, my road to feeling like I have a style and a manner and a technique of brief writing.
Well, so you were at Hoover Slovacek for a long time, but you've had it's not so recent anymore, I don't guess, but still pretty recent change, and you have gone over to the plaintiff side of practice. So you're practicing with Randy Sorrell's, and well, it's really his entire law firm, Sorrell's Law in Houston these days. How did that transition come about?
Well, so let me say I did in 2008, I kind of jokingly call it a sabbatical now. I left Hoover Slovacek and moved to Austin, where, of course, I was born and raised. And my wife is from Louisiana. She'd never lived anywhere in Texas besides Houston, which is where we met. It was an opportunity, where I was at that, 5-year range where, you're pretty experienced and not too expensive. And so, I was able to take advantage of switching firms. It wasn't quite the right fit. So I did come back to Hoover Slovacek. So other than that 6-month period in 2008, I had been at Hoover Slovacek basically all the way from my, the summer of my after the 2L year until last July. And so Hoover Slovacek it's not, I wouldn't really call it a defense firm. I mean, they did not do insurance defense. Occasionally they had some cases where there was some insurance involved, but we were not on any insurance company's list, but we would handle all kinds of, litigation, plaintiff, defendant, not personal injury. Occasionally we'd defend some where there was no insurance involved, but a very broad variety of commercial real estate litigation. But because of the limitation of what we did, or at least what we didn't include, personal injury, that we had a good relationship with, Randy's prior firm, Abraham Watkins. So they would refer commercial cases to us and we would refer personal injury cases to them. And so we had always, had that relationship. And then, and I knew of Randy that way, but I got to know him even better when let's just say we had 2 different cases with a common opposing counsel. Let's just put it that way. that we shared some thoughts about, and so he was always someone that in the back of my mind, obviously, one of the best trial lawyers in the country, certainly the state. So, and that kind of goes to my point about that I'd mentioned, when we were thinking about maybe doing this podcast. Is, I tried about 10 cases as first chair jury trials, and then a bunch of bench trials and some arbitrations, and I always liked doing that. But obviously when I decided to maybe sit for the board certification appellate bar, which I was qualified to sit for, a lot of that trial work started going away, and I did mostly appellate work, and then did some, embedded, wearing my appellate hat in trial, which I did, a decent amount of, not as much as a lot of appellate lawyers would do. But I guess I started to miss the trial work a little bit. And then after, 20 plus years of doing commercial real estate and, those kinds of litigation, I kind of wanted to do something different, and so I reached out to Randy, and when we met, and that was July of last year. July 15th was my first day, and I'm glad I made the move. And I can't talk about the details because it was an arbitration, but he and I tried a case just last month, and so that was fun to see him in action. And I'm dusting off my trial skills, but I'm looking forward to doing a lot more trial work, but still, I still like to keep doing some appellate work. I just like to do both, and the way I think about it is, particularly when I when I've had about 5 oral arguments in front of the Texas Supreme Court. And the first time, of course, is pretty nerve wracking. And then the more you do it, the more comfortable you get. That, the way I kind of get myself mentally in a place to do these oral arguments is I just say to myself, it's kind of a mantra. I'm just talking to judges about the law. And that's what I tell, young attorneys. You're just talking to judges about the law. And that's what I like to do. And I was I'll tell you, I was one of those guys when we would go to lunch, firm lunch, and there's a bunch of guys going wherever, and everybody else would want to talk about everything but the law. And I was the law nerd that was like, hey, did you hear about that case? And, oh man, did you know this about the law? And everybody's like, Dylan, come on, keep that at the office. But I just like the law so much that I think about it all the time. And so there's never any point at which I think I would have to say, well, I'm only going to do trial work now, or I'm only going to do appellate work. And then just like talking to judges about the law is what I feel like I'm doing in front of an appellate panel. If you're in a trial court, you're talking to one judge about the law. And then to some extent with the jury, you're sort of educating them a little bit about the law, or at least how you think the facts should apply to the law. So obviously who your audience is different, and so you got to treat it quite differently or somewhat differently. And I'm definitely going to be learning a lot from Randy about, all the experience he has with in front of juries. But, it's pretty similar. If you can tell the story or explain a complicated concept simply enough for whether it's a jury or a judge that hasn't been sitting with a set of facts or maybe an area of law that they're not as familiar with as you are, you're just trying to make it as simple as you can. And so there's a lot of similarities between, how you explain something to a jury and how you explain it to a panel of appellate judges.
So at your new firm, since you're doing both trial and appellate work, do you still get brought in as the appellate guy sometimes? And kind of when does that happen in the process?
Yeah. So for example, we had, a pretty significant win in a case that Randy and Alex had tried, relatively, well known. So it was Roger Clemens' son and his buddy, professional baseball players in their own right, got roughed up at a bar. And I'm putting that mildly, pretty serious injuries. And they got an excess verdict of over $3.2 million. And the insurance company decided they did not want to pay it under the Stowers doctrine. So they filed a federal district court case, essentially seeking a preemptive federal declaratory judgment act claim, seeking to declare non-liability under the Stowers doctrine because they didn't think that the Stowers demand letter was sufficiently clear to put them on notice. The other board certified civil appellate attorney here in the office, Vic Thomas, wrote the briefs, and I got to argue it, and we got a pretty quick turnaround result, and they remanded for the case to be dismissed. And so now the Stowers claim and a legal malpractice claim are pending in Harris County district courts. That was an example of where I get to kind of come in and do the fun part of the appellate practice, as you guys well know.
Yeah.
And then, we've had some cases that look like they're about to go to trial, and we, worked on some jury charges, but I'm also taking depositions and, splitting up trial with Randy recently. I did the opening, he did the closing. I took some witnesses, he took some others. So, but, I think the great thing about this firm, by the way, we have 25 attorneys now, and
Wow.
We'll be growing, and that's in a pretty short period of time. We are very collaborative. We're always sharing ideas. I mean, literally on a daily basis, we're sharing ideas. It could be on something small, it could be on something big, and definitely, us two appellate nerds, Vic and I will get together and, brainstorm on the appellate stuff. And we, go to the trial gurus when we have questions about that. So,
it's interesting. You think about a personal injury firm and you think about, trying cases where people get hurt, but there is a lot of that kind of background insurance stuff, coverage litigation, all the kind of incidental things that help keep the lights on and make sure that your clients get money at the end of the day that really do matter.
Yeah, there is a ton of that. You hate to call it satellite type litigation, but you're right. I mean, those kinds of issues, you got to deal with them. If the carrier is not owning up to the responsibility, it's going to make a big difference in the ultimate outcome.
Yeah. And, in my prior firm, we just didn't have that many cases where it made sense to make a Stowers demand, nor were they rarely sent, to one of our clients. But it's just, it's a very common practice, particularly, for these smaller companies. The big Fortune 500 companies, they're presumably going to have sufficient assets to cover a judgment if there's a sizable judgment. But a lot of these smaller companies, they've got a handful of employees, or, they're leasing their equipment. And without insurance coverage, there's oftentimes not going to be, any cash available to collect on a judgment. You definitely don't want to go through the difficulty and of litigation, only to find out that you ended up, with a piece of paper with a number on it that doesn't do the client any good. So, that's why the public policy behind the Stowers Doctrine is such an important part of Texas jurisprudence. I mean, it's almost 100 years old. I know the Stowers is a 1929 opinion, so we're coming up on a 100-year-old doctrine that that has protected the insured, right? It protects typically the defendant from an excess judgment. So for small business owners in particular, I mean, you got to think about how important that is, for big Fortune 500 companies, they're obviously going to have, good insurance, but for smaller companies, I mean, you're putting companies out of business if they have to pay a judgment, let alone an excess judgment, without insurance. And that's why, and we all want insurance, right? I mean, that helps.
Yeah, absolutely.
Litigation, get settled and helps people who get injured or worse, get some compensation for that.
You mentioned Vic Thomas. I remember when, I think maybe there was an announcement when he went over to Sorrell's, and I think was maybe the first appellate lawyer in the firm. You'd think that I'm like a groupie of, other law firms and really monitoring what they're doing. But, you read the news and you see things written up in Texas Lawyer or Texas Law Book or Law 360. And I remember seeing that because I mentioned before we started recording that I've known Randy since he was state bar president and I was on the state bar board. And so, naturally when he and Alex made the move and started their firm, I thought, oh, this is really interesting. And then it's been hard to avoid in the legal news because the firm has just blown up and been so successful. And Randy, as you point out, continues to be written up as, top trial lawyer, and it just had a lot of success. And so I was curious though, whether you and Vic kind of make up an appellate section within the firm. I know you've got your, 1 foot in trial practice, but is it that organized, or do you just kind of, everybody works on cases as they come up?
Well, I mean, Vic is, he's doing exclusively appellate work in the sense that, whether that be jury charge work, summary judgment, response, those kinds of things. And I'm doing both, but definitely, Vic and I are the appellate guys. And there's other, great trial lawyers who handle their own appeals on occasion. And that's frankly how I started. It wasn't until maybe years later, probably more after I got board certified, that I started completely doing just the appellate work. Trial lawyers had done all of the trial work, and then I'm stuck with the record, as you know, when you're just hired as appellate counsel. But we're definitely the appellate section, you would call it, but it's not that it's not organized in that way. It's a very collaborative firm, so we're always bouncing ideas off each other, whether it's an appellate issue, a trial issue, or as you all know better than anybody, a little bit of both, right? You're always trying to think of what happens in trial, what's that going to look like if it goes up on appeal. And I think that's somewhat of an advantage of having done all the trial work that I have done, and then still doing the appellate work. Doesn't make it well, maybe it makes it a little bit easier, but what I was going to say is it definitely is easier in the moment if your sole task is to be the trial lawyer or your sole task is to be the appellate lawyer. But I think as an appellate lawyer, definitely those light bulbs go off, the bells ring in a moment in trial where you realize, we're about to, should we let this testimony in, or should we keep it out? Or is this going perfectly, or do we need to make an objection? Did the judge really rule? I mean, all those things are probably more ingrained in us. But if you're thinking about those things, you're maybe not quite thinking about, how is the jury reacting, right? So it's difficult to have two hats on at the same time. But I don't think I think it can help you in the right moment, but it's also great to have trial lawyers who were focused on nothing but the jury.
Mm-hmm.
And so, yeah, I think I answered your question and then,
Oh, yeah.
then some. But we definitely have a bunch of trial lawyers that are happy to do nothing but trial work. And then Nick and I are happy to pick up the appellate stuff when it's appropriate to do so.
Sure. I just remember, the first firm I practiced with was one you're familiar with, Fulbright and Jaworski. And there were lawyers. This is not about me, but I came up, I spent half my time in litigation and half in appellate. That was intentionally the structure. And it worked out great for me because I learned a whole lot about trial work that I wouldn't have learned, or it would have taken me years and years and years to learn if I had gone straight into an appellate section. So, there's a lot of value, I think, in the approach of having that kind of involvement in trial work. And there were some lawyers in my former firm who, that they were trial and appellate lawyers. They did not market themselves as one or the other, but they were kind of considered, and I think this is accurate, they were kind of unicorns. You don't tend to see people. I always say, there are a lot of trial lawyers who can speak and write well, and they're smart, and they can study a case, and they can present an argument. But there's doing that day in and day out, like most appellate lawyers do, versus the kind of things you have to do as a trial lawyer, like depositions, experts, broader case strategy. There is some overlap in those skill sets, but there's also a lot of things that are very different about it. So I admire and respect someone who really can do both. It's kind of like being bilingual, I guess. You can operate in both worlds effectively. But so I respect that approach, and having had success on the trial side, and develop skills there, also not necessarily wanting just to completely give that up. Or I guess maybe it'd be more accurate to say, Dylan, kind of go back to cultivating those skills and doing those sorts of things, because it kind of sounds like you were really focused on the appellate side for quite a while.
Yeah, I have been. But I've always had clients that, wanted me as their trial counsel. So, it's been a while since I've had a jury trial, but I think the last ones, I can't remember how long ago, not too long ago, but a while back, I actually had 2 jury trials in the same case. That was with, this will tell you how long ago
That's
it was.
special.
But
It
was Judge Tad Hallback. And what happened was it was, liability, damages, attorney's fees were awarded, but the attorney on the other side did not segregate the attorney's fees between the tort and the contract claims. And Judge Hallback, looked at the other side, said, I got to grant a new trial. So we picked a brand new jury about a couple months later.
Oh, gosh.
And, tried just the attorney's fees. And it, ironically enough, the award was exactly the same, almost exactly the same dollar for dollar, even though we had to go through the trouble of trying the case again. And then, being the trial and appellate attorney that I am, I got to argue that on appeal. And the opinion author was none other than Justice Jane Bland when she was still on the First Court of Appeals. And I remember her saying during an oral argument, she says, so if we reverse and remand for a new trial, which was the only relief I could get, right? If you don't segregate attorney's fees, then, there was actually another issue. The issue was there was no evidence of the amount of damages that had been awarded in the verdict, which was one of my motion for new trial grounds. And so Justice Bland said something along the lines of, so if we reverse and remand, you'd have yet a third jury trial in this case? I'm like, yeah, I'm sorry to say so that's true. And that's well, we got the reverse and the remand for a new trial. And then, basically everybody threw up their hands and gave up and decided we'd all had enough. So yeah, that was a fun one. But yeah, that was basically the last major jury trial that I did. And then since then I think it was after that I got board certified in appellate work, and then did a handful of jury trials as appellate counsel, and then had a couple of bench trials as lead trial counsel, but not a jury trial. But it's fun work.
How do you approach taking a witness and things that appellate lawyers just don't do?
that is the truth.
I do it when I have to, like in a supersedious hearing or something like that. But that's about the only time I want to do it. How do you change gears in your mind?
Yeah, to me, the way I learned to do that And it's really the best way to learn. And I'm always surprised when I hear, I won't name any names, but they'll admit it to you with no problem in person. But a lot of appellate lawyers have never taken a deposition, and that's unbelievable to me.
Mm-hmm.
I mean, I get it, depending upon, if that's where you wanted to start your practice, or if you came from transactional, and ended up just doing appellate law. But I mean, that's where you really learn how to handle a witness,
Mhm.
whether you're watching your client get deposed and seeing, good and bad lawyers cross-examine your clients and your witnesses, and vice versa. I mean, that is the opportunity to test out your skills and how to pinpoint, get a witness to when they're being non-responsive, how to get them to ultimately answer if you can. And sometimes it's just almost impossible. And that of course is the function of not having a judge and a jury sitting there, right? They can get away with stuff that they would look ridiculous trying to get away with in front of a judge or a jury. But that's basically the skill. And I was lucky to have, speaking of, Randy's trials, he had that big one against Rusty Hardin. And I was fortunate early on at Hoover Slovacek to have a case where we had co-defendants, related companies, a home builder, and then the related development company were represented by the home builder. My firm represented them in a case that went to trial, and the developer used Rusty Hardin and his team to represent, the developer at trial. It was a mass action case, so like 130 individual plaintiffs represented by a group of plaintiffs' attorneys. It was sort of we call it the leaking lake case. And I got to cut my teeth as far as deposition goes, because there were, basically mostly husband and wife in a, area of Fort Bend where, nice houses. And there were some issues with some of the development work early on by some contractors, and that led to the lawsuit. And so I took about 150 depositions with Rusty Hardin's, some of his top associates at the time.
Mhm.
So learning from those guys and the practice of taking those depositions. Once you get in a courtroom, you pretty much know what you're doing with cross-examination. For me, direct is a lot tougher, than cross, because you've got to expect the witness, particularly if it's your client or an expert, you can't lead them, right?
Right.
So
Right.
they kind of
Mhm.
have to do a lot more work than when you're leading an adverse witness, and that's in my mind a lot easier, but still tough. It's an art, but
That's a
yeah.
good
I guess
point.
totally. With direct, I mean, you've got to spend a lot of time preparing the witness to make sure that those facts come out that you need them to, and you're not, as you suggest, you're not in control of what the answers are.
Yeah, you definitely never know what's going to come out. And this isn't a war story, but it goes to this point of you never know what your witness that you're presenting is going to say. But I had a Perry Mason moment to my benefit where it was a race discrimination case, and the only witness to the statements that reflected discriminatory animus were by the literal cleaning lady, and who overheard some management person say something that was definitely discriminatory in nature if it was true. And so she had signed an affidavit that had been translated from Spanish into English, and I was sort of grilling her on the affidavit. And I said, well, so tell me about how you came about signing this affidavit. And she didn't quite understand that it was totally normal for the attorney for the plaintiff to have prepared that affidavit after talking to her. But she didn't understand that. She thought that was something that was supposed to be secret. So I'm asking her, well, how did this happen? She says, well, I'm driving with my daughter, and she said she was thirsty. So we stopped at a Denny's to get some Coke, and we get out, and there's the plaintiff's attorney. I'm like, so how did you know it was the plaintiff's attorney? Did she have a sign that said, hi, I'm the plaintiff's attorney? And anyway, it was clear that she didn't think it was appropriate for her to have met with the plaintiff's attorney and talked about the facts and, gotten the affidavit drafted. So I said, all these things that you've been saying for the last hour, have you been telling the truth? And she goes, no. And I'm like, oh my God. And of course the plaintiff's attorney's like, oh my God. And so I said, well, why have you not been telling the truth the whole time in this deposition? And she says, well, because I'm nervous.
Oh,
And this is all being translated, so I get the benefit of the translation, the length of time between each question and answer. And then I say, well, if we go to trial in this case, we're going to be in a courtroom with the judge and 12 jurors, and are you going to be nervous then? Yes. So I said, will you be able to tell the truth at trial? No, I won't.
Oh, wow.
So needless to say, that case settled pretty quickly after that, because that was the sole witness who had allegedly heard this bad sounding statements. So
gosh.
if you haven't, so as the attorney presenting a witness, whether it's your client or a fact witness who's supposed to be favorable to your client, you better have spent a lot of time preparing that witness for anything and everything. Because that's super important. Obviously, on direct, you want to have prepared them for what you'll ask and what they'll say. But even when you're just sitting there, you better have prepared them for what could come from the other side, so that they know kind of what to expect. Because it's a difficult thing if you're not, an attorney like we are, and you've seen it from so many angles that you kind of can be prepared for it.
And that's also where your jazz training and improv kicks in, because you have to just be able to adapt to the moment and go with it.
Definitely.
I'm telling you,
I've done some.
There's a parallel
tap
here.
dancing.
The one thing about jury trial work in particular that I think has always sort of intimidated me is voir dire, because that is so unlike anything that I do, as an appellate lawyer day in and day out. And so, what's your take on voir dire? How do you approach it, given your particular breadth of practice?
Yeah, well, that's something that I'm definitely learning, that, Randy can do that in his sleep. He's done it so many times, and we're all learning from him and some of the other great trial lawyers here in the firm, and others in the community of top plaintiffs attorneys across the country share lots of ideas. And I mean, it's an art, it's not a science, even though there's a lot of science that people have attempted to do. But at the end of the day, what I have learned, both with my actual firsthand experience, but with also talking to other trial attorneys and even appellate attorneys for, the error preservation part of it, which is critical,
Absolutely.
is making sure you're getting the jurors off that are not good for you. That I do think, you have to have a careful combination between definitely getting bad jurors off and also trying to earn the jurors' trust. And obviously you don't want them to dislike you. That's never going to, be helpful if they dislike you for some reason. But at the end of the day, if you're not getting jurors to talk, you're not learning anything, because all the things that people used to think were relevant, what their job is, are they an engineer, those kinds of things, obviously demographic factors. I mean, they just, you got to get them to talk. If for anything, you need, obviously you're trying to learn what they believe, but at the end of the day, as you all know very well, the only thing that matters for purposes of a record is what the witnesses or the jurors say, right, on the record. So if you're not getting them to talk, you're definitely not going to get a strike if you think this is someone who should be stricken for cause. And so if you find yourself talking too much, you're losing, voir dire at the end of the day. And then obviously when you have time limitations, as almost, depends on the judge, obviously, you want to learn how much time you're going to have. And if you have some limited amount of time in a complicated case with lots of issues, then you got to figure out some technique to get a couple of the jurors, really talking and expressing an idea, and then doing your best to loop, those answers. Juror number 2, do you agree with what number 1 said, or try to get as many jurors to take a position, whether they agree or disagree with whatever some juror said. And the skill and technique and art of doing that in a limited amount of time is, that's really where the best of the best can really make a huge difference in the outcome of a case.
That makes a lot of sense. I mean, we see jury consultants who don't do anything but help pick juries. And so, there's definitely room for specialization there, but that's just, every time I'm in trial, I'm like, no, I really don't want to take a witness, and no, you don't want me around for voir dire. I'm not going to be any help to you at all. So it's that's another level of skill that I certainly admire.
I think for the appellate lawyer, obviously the key there is if you're starting to, you feel like you're running out of strikes for cause, and you've got a pretty long list of peremptories, then the skill of getting a bad juror to commit that they can't follow the law, or they can't commit to following the law on an amount of damages if the weight of the credible evidence supports a damage number that's in a certain range. If you can't get the commitment, then and you have to get the commitment before the defense attorney tries to rehabilitate.
That's right.
But you can be fair and you can follow the court's instructions. If you haven't gotten the commitment prior to the defense attorney doing that, you may never ever be able to recover, depending upon how flexible the judge would be in bringing in that juror on a one-on-one basis and really fleshing it out to make sure you've got that definitive answer.
Which is something I've actually done as the appellate lawyer, is the one doing the one-on-one questioning and making sure you're asking the right questions when they bring them back.
Yeah. There's a big trial. I was just watching it. I think they probably paused today. Harris County Court, some of our courts have live stream, and none other than former Judge Daryl Moore, as I'm sure you all know, board certified civil appellate attorney, was doing that appellate voir dire work yesterday. So learning from his team and everybody else. So that's a great resource, by the way.
It is.
I love it when appellate lawyers go on the bench, and not just as appellate judges, when they go on the bench as trial judges. I mean, what a cool experience for them. And then, how much did Judge Moore learn about the nuts and bolts of trials while he was on the bench? I mean, what a tremendous opportunity for him as a now former district judge to bring that forward into his work. Well, I want to wrap up with one more question, Dylan, before we kick it over to the war story. Is there anything, we talked a lot about your involvement in trial work and your unique position sort of straddling the line between trial and appellate work. Is there anything that you wish more trial lawyers understood about appellate practice and what it is and what goes into it?
Well, I mean, I think the thing that sets even better trial lawyers, no doubt appellate lawyers, and how important it is. It's sort of an error preservation point, but it's also a persuasion point, right? As we all know, it's always better to be appellee or respondent statistically than appellant or petitioner. And I think very in-depth research, I think that skill has become, and I've been asking, brand new lawyers coming in to the firm, and all the years that I kind of would help train new lawyers or law clerks, that, the writing part is definitely something that is, there's a lot of focus on, but the research skills, I think there's, as we all know, with some of the horror stories we've heard recently about the use of AI to do legal research, that the skill of doing legal research and finding, the cases, there may be one case that's directly on point, how important that is to preserve error, to get the trial judge convinced that, hey, judge, this is the law. And, I'm telling you, if you don't follow this law with these set of facts, we've just preserved an appellate point. And so the better your research skills are, the more persuasive you can be to the trial judge. And then obviously, if you still aren't convincing the trial judge, then you've got a great appellate point. But if you haven't done the research, then as you guys know, you may have waived that argument. And as we all know about the Texas Supreme Court's very, liberal error preservation jurisprudence, you just need to at least make as clear as you can to the trial judge what you're complaining about. And if you have a case on point, it couldn't be any better than that. And so, doing that research and doing trial briefs, in advance of trial or in advance of an important hearing, or just if you're filing a response to a motion for summary judgment that a trial attorney may argue or an appellate attorney may argue, if your research isn't spot on, super in depth, and cited appropriately and cited persuasively, like, if I'm in a Harris County District Court, I'm either citing to the 1st or 14th Court of Appeals or the Texas Supreme Court. Why would I cite an El Paso case? They don't. It's not binding, right? And you'd be surprised how often, I found the case that says what I want, but I'm going to cite an El Paso court, Court of Appeals instead of Houston. It makes no sense. So anyway, that to me is sort of the thing that I wish trial lawyers knew, how that appellate lawyers know, that how important that briefing is and the research is to get that good briefing in front of the trial judge, so that hopefully you can persuade, but if you can't, at least you've hopefully preserved error on appeal.
Good point. Well, as we kind of wrap up, it's our tradition to always ask for a tip or a war story. And I know before we started recording, you said you had one in mind, so let's hear it.
So it's a combination, but mostly a war story, but a little bit of some tips, probably 2 tips. So I had a case that I did not start, but it was a very long ongoing case that started in the 269th.
That was my court. That's the one I clerked in when I was in law school.
Yeah. So 69th, and it was a dispute about a technology invented by a former consultant for a big company. It was an excimer lamp that used UV fluorescence to detect sulfur oxide in oil and gas. And a lawsuit was filed over whose technology that was it the consultant or the company's? And it ends up going to arbitration because there was an arbitration clause. It was a 3-panel arbitration. The technology is declared to be the consultant, not the company. Goes up on appeal, it gets confirmed, there's appeals. And then the allegations were the company went ahead and started using the technology that was declared to be this individual's anyway. And long story short, there was a bankruptcy from a related company. It ends up in Judge Hughes' court, Lynn Hughes. He withdrew an adversary case from bankruptcy, and we tried the case. And there was an example of where I was appellate counsel and tried the case. He issues a ruling, unfortunately not favorable to the client. So I argued it on appeal to the Fifth Circuit, and unfortunately did not get the reversal we were hoping for. So obviously we had one last place to go, the U.S. Supreme Court. And we had an issue that it was the issue of full faith and credit. Article 4, Section 1 of the United States Constitution is the full faith and credit clause. And then there's an act that Congress passed consistent with that. And the idea was, if you're saying that this technology was not this individual's, that's contrary to a order clarifying what the technology was from the state court judge who had signed an order saying, here's the technology and it belongs to this gentleman, not this company. So I started drafting a cert petition at the U.S. Supreme Court. And now this was during COVID. So one of those COVID orders was in place. So a lot of the deadlines were extended. And so I was going to make sure I spent as much time to make it as good as I could to get it on file. But unfortunately, the timing of that event was the Winter Storm Uri.
Oh, no.
Which hit where I live, Missouri City, Sugar Land area, southwest Houston. And as we all found out, that essentially put our power grid under. So if y'all have ever done U.S. Supreme Court cert petitions filings, you electronically file, but that's not the official filing. You have to paper file it.
Right.
And usually use one of these services, that does it, but we weren't in a position to do that. Well, I thought, I'll just mailbox rule it, put it in the mailbox, which would be sufficient. Well, the problem was nothing was open. So there were no mailbox services anywhere. So I didn't have a printer. So, cause there was no power. And so luckily a neighbor friend, many subdivisions away from mine, they happened to have power. So I go over to her house, print out the petition and stuck it in an envelope, hand addressed it to the U.S. Supreme Court clerk, put a bunch of stamps on it, took a picture of my Apple Watch with the date and the time on it, and with me dropping it in the post office box, knowing that it wouldn't be picked up for a couple of weeks.
Oh my gosh.
And so my first cert petition was filed mailbox rule by hand. And, I wish I had a better ending, but we did not win the cert petition.
Did they at least file it though? Did they?
But we did file it. And, I've got, that was my first cert petition. But so the lesson there is, the tip is remember the mailbox rule if you need to. And then but the second tip is don't wait until the last minute to file your document in case you have, a hurricane or winter storm.
Once in a lifetime winter storm.
Yeah.
Exactly.
100-year storm.
Just when you think you might have power, you may not.
Jeez, yeah.
So,
I think that we joke around about war stories, but I think that one comes the closest to being an actual war story.
Yeah, a natural disaster, force majeure story.
That's right. Well, Dylan, this has been great. Thanks for spending the time with us. We appreciate the chance to visit with you, and just, we're grateful for you being willing to come on the show. And
well, I really appreciate it. And I'll tell you one last thing. You guys inspired me to start my own podcast, but I did not have the stamina and fortitude that you guys did. I stopped after 17 episodes, and I will ask since I got you, on audio, and that if I pick it up, and I may again, I would ask for you guys to come on and be my reboot guests. So if you guys are interested,
you let us know. We'll be there.
Well, we certainly would support you in that venture. Let us know if you decide to boot it up again, and we'll be happy to oblige.
Houston Law Nerd Podcast. So my next episode would be, I think, 18. So you guys will be 18 if I decide to pick it back up.
Okay. Well, let us know.
Very good.